Chapter 8 is going to be on property rights. Let's talk about land, real estate, and real property. Land is the surface that we're buying. Real estate is the land and everything permanently attached. Buildings, trees. Real property takes it one step further. Real property is the land, everything permanently attached, but it also includes what we call a bundle of rights. In other words, what can we do with it? And if you'll look in your textbook, the physical components of real estate are your surface rights, your air rights, and your subsurface rights. Now, as far as your surface rights, that's everything that you see on the surface. Subsurface rights include everything all the way to the core of the earth. In other words, everything down there. Sometimes we call these mineral rights. And then when we talk about air rights, that's all the rights that you have all the way into the sky. There are also certain water rights and restrictions that we have. The basic ones that we want to talk about are riparian rights and littoral rights. An easy way to remember the difference: riparian rivers, littoral lakes. Now let me explain. Riparians are flowing bodies, rivers. Littoral are tidal bodies, those more stagnant bodies. And what this basically has to do with, what rights does a person have to property that abuts certain water rights, and that's described in these laws. I want you to also look during your studies at erosion, accretion, and alluvium. Those are other types of water restrictions that we have, or water rights, that you're going to need to look at for the state examination. Let's talk about real property versus personal property. I've always been a believer that if it's been screwed or glued, it's real. But there's a lot more to it than just that. Real property is, remember, real estate, that surface and everything permanently attached. So what is personal property, and what makes personal property become real property? Personal property are those things that have not been attached. Let me give you a good example. If you have a ceiling fan in a box on a table, it's personal property. Once you take that ceiling fan out and you install it bolted in, it now becomes part of the real estate, the real property. So we call that a fixture. And let me tell you how we do the determinations of whether something is real or something is not. The legal determination is this: what is the intent of the parties? What is the method of attachment? What might be the agreement between the parties? And what is the adaptation of that particular item? All of these are going to play a role in determining, whether they are considered to be real or personal. Basic property rights that we have. We talked about real property and that bundle of rights. What is that bundle of rights? That bundle of rights, or that basic property right we have, can be categorized in 5 ways. The acronym is Deep C: disposition, enjoyment, exclusion, possession, and control. Those define what our basic property rights are. It's that bundle of rights. Now, to segue into what this is all about, we're going to talk about both freehold estates and non-freehold estates. 2 different ways of having an interest in real property. Freehold estate is ownership. Non-freehold estate is less than ownership. So let's take a look at the freehold estates first, the ownership part. There's 2 ways that you can own real property. 99 and 44, 100% of the time, it's going to be in fee simple. And when I say fee simple, you enjoy that full bundle of rights, Deep C, that full bundle of rights. In a life estate, there's something missing. What's missing is disposition. In a life estate, someone has received title to property, but at the expiration of somebody's life, that property is going to go to somebody else. Now, the way it works is simple. If I gave my father a life estate and he can own it for as long as he's alive, but when he dies, I want it to revert back to me, I have a reversion of state. He has the life estate and he can do anything he wants to with it. It's his. But whoever, in fact, he could even sell it. But whoever buys it has to understand that when my father dies, it comes back to me. So it'll have to be spelled out in the deed. Now, if I gave that same property to my father, but when he passes, I want it to go to the Boy Scouts of America or the Pensacola Yacht Club, what will happen is that upon his passing, title will transfer to one of those two entities. They are considered to be a remainder estate. It will not be coming back to me. It'll be going to a third party. The non-freehold estates, on the other hand, are less than ownership. This is renting or leasing. So what I want to do right now is I want to break these out and kind of line up to the degree of how enforceable they are. The first one is an estate for years. Now this one is really a true lease. It has a beginning date, it has an ending date, and it has to be in writing. And the only way that you can get out of this lease if there's a breach, if somebody doesn't do what they're supposed to do. Otherwise, you're in that lease for the duration. Now, if those three components, beginning date, ending date, and in writing, if all three are not part of the lease agreement, then you have something less than a tenancy for years. What you probably have is a tenancy at will. The most common tenancy at will is a month-to-month renter. You have a beginning date, but you don't have an ending date. That's an unknown. The fact is that if you are a month-to-month renter, a tenancy at will, we can evict that person with a 15-day notice. Now, the deal is this, that 15-day notice has to be given prior to the first or on the first of each month before they pay their rent. Because once rent is paid, then you have to wait until you have a clear 15-day notice for the termination. A week-to-week renter, you've got a 7-day notice. Now, the other way that a person can have an interest in real property is a tenancy at sufferance. And let me tell you what that is. That's a person that's a holdover, a person that had a lease, they had an interest, they either had an estate for years or a tenancy at will, but it expired and they're just holding over. Now that one can be terminated immediately. The next topic that we need to talk about is going to be the homestead. Florida is one of a few states that have homestead. Not all the states in the United States have homestead exemptions. And what the homestead provisions provide is that that homestead is protected in a number of ways. One, judgment liens cannot foreclose a homestead. Now, other type liens can. Mortgage liens can, tax liens can. There are several liens that can foreclose a homestead, but not judgment liens. In addition, it protects the spouse from being disinherited. Now, let me explain that. If I own a home in my name only, and I get married, and it is my homestead, I can't sell that home without my spouse's signature on the deed. In other words, I can't sell it and leave her behind. I can't disinherit her. If I died, even though she's not on the deed, she automatically has an interest in that property. And if we have kids, she'll have a life estate, and the kids will also have an interest in it as well. But if we don't have kids, she'll get it in a fee simple estate. So bottom line is the way we got this set up in Florida, that spouse cannot be disinherited. Specific types of real property ownership include estate in severalty. Here's an easy way to remember this one. You're severed from others. In other words, you own it by yourself. You own it solely. The estate is owned by a husband and wife, or it's the marriage that owns it. It's called a tenancy by the entirety. In other words, the husband doesn't have 50% or the wife doesn't have 50%. It's the marriage that owns it, so they can't sell it separately. The joint tenant, however, is a little different. The joint tenant is not for husband and wife, or it's not for the marriage. It could be for brothers and sisters, it could be for any number of people. But what you have is equal use, rights, and ownership and privileges to that property. In other words, 25, 25, 25, 25, 50, 50. It's got to be equal use and rights. The acronym is PIT. It has to do with possession, interest, time, and title. They've all got to be the same, and they all had to purchase it with the same deed. In addition, there has to be a special clause in it that gives a right of survivorship. And let me explain what a right of survivorship is. If one dies, the others get it. It has to be spelled out in this one. The tenants by the entireties, it's automatic. There's a built-in right of survivorship. But in the joint tenant, it has to be spelled out. Now, if these criteria aren't there, then it's not a joint tenant. Let me explain. If there's 4 of us that own a property as joint tenants and one decides to sell it to somebody else, they're allowed to. But whoever that other person coming in that's buying that 4th interest cannot be a joint tenant. The very best they can be is a tenant in common. So they can't share in that survivorship. They're not a participant in that survivorship. All a joint tenant is where you may or may not have the same interest, rights, or use, and there is not a right of survivorship. Condominiums and cooperatives. This is what made Florida famous. Let's do them one at a time. First of all, a co-op, since co-ops were created before timeshare were. That's found in Florida Statute 719. And all a cooperative is, it is a corporation that was created to own a building. And the stockholders of that corporation enter into a proprietary lease for the use of their space only. So there's a proprietary lease involved in a cooperative. But remember, it's still one building owned by one corporation with multiple owners of that entering into proprietary leases. As far as rescission, I'm going to talk about rescissions on all of these, but remember that when you buy a cooperative, if it's a brand new cooperative, you have 15 days to change your mind from the date that you entered into the contract to purchase it, or that you receive the appropriate cooperative documentation, whichever comes first. If it's a resale cooperative, you have 3 business days to rescind. The same thing applies to a condominium. Now let me explain what a condominium is. The condominium is where we have individual ownership in a multiple unit dwelling. And let me tell you how complicated this is and why they're so expensive to create. You're going contrary to common law. Common law, we've already said, says you have surface rights, air rights, and subsurface rights. Well, when you're in a unit of a condominium, you're agreeing by law with the condominium documents to give up air rights and to give up subsurface rights. They no longer belong to you. So with a condominium, what you're doing is you're creating an environment where you're going contrary to common law. It's individual ownership in a multiple unit dwelling. You have the same rescission period that you have with the cooperative. New unit, 15 days, or resale, 3 business days from the time that you either receive your condominium documents or you enter into a contract. Whichever of those come first. Now, that's found in Florida Statute 718. Now, the one that I think that we also need to focus on that we don't think about is timeshare. Timesharing is where we took a condominium concept and broke it down into even more individual uses, maybe 50 uses or 52, whatever it might be. With a timeshare, that's found in Florida Statute 721. They do not have the same rescission period. With a timeshare, you have a 10-day rescission period from the time that you get your public offering statement as to your acquisition or your purchase of that timeshare. If I were you, I would become familiar with chapter 7:19, chapter 7:18, and chapter 7:21. The reason for that is it goes contrary to all of the contracts. These three purchases have a rescission period. No other acquisition has a rescission period. And that's all I've got for chapter 8 on property rights. So what I want to do right now is I want to go ahead and get into our review. Real property is the land and everything that's attached and the bundle of rights. Personal property may become a fixture. And the way that we look at that is what are the intent, the method of attachment, the agreement that the parties may have, and the way that it's adapted to the property. A bundle of rights include disposition, enjoyment, exclusion, possession, and control. We can own real estate in either fee simple or life estate. Remember, the bulk of the time, in most cases, it's fee simple. The homestead, remember, is protected from judgment lien foreclosures. Attended by the entirety, this is your husband and wife, or the marriage ownership. The joint tenancy is equal possession, interest, time, and title. They all have to be equal. They had to purchase at the same time with the same deed. And there has to be a stated right of survivorship. Condos and co-ops have rescission periods. If they're brand new and never been sold before, 15 days. If they're a resale, it's 3 business days. And in both cases is from the date that they either receive their proper documentation or entered into a contract, whichever comes first. Timeshare rescission period is 10 days from the date that you get your public offering statement. Water restrictions include littoral and riparian rights. A life estate terminates when somebody dies. A tenancy for years has a beginning date, an ending date, and is in writing. A tenancy at will, this could be a month-to-month renter that is a beginning date but no ending date. And that can be terminated with a 15-day notice. A tenant at sufferance is simply a holdover with no agreement. And that is the end of my Chapter 8 review.